The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Welcome to Deep Dive with the Institute for Justice. I'm Melanie Hildreth. In the last year, the dollar value of Bitcoin has increased more than 700%. The market value of all coins is now worth more than companies like Apple and Amazon, and corporations like Tesla are purchasing and holding large amounts. With cryptocurrency hitting the mainstream, we thought it would be interesting to look at it from the perspective of the Constitution. I'm here with IJ senior attorneys Bob McNamara and Jeff Rose, who are not experts in cryptocurrency, but are experts on the constitutional protections for free speech and property rights. I want to start the conversation by paraphrasing a few comments from entrepreneur and investor Naval Ravikant. Talking about Bitcoin, he says that now money is just code and code is speech, which makes money and speech essentially the same thing. So if you're trying to keep speech free and also trying to restrict the flow of money or cryptocurrency in this case, those two things just can't go together. Jeff, when you hear money is just code and code is speech, how do you start to unpack that from a legal perspective? What is the framework that people should start with as they think about it?
Well, it's an interesting philosophical framework, and I understand how that's a compelling, forward-looking, modern way of thinking about things. In the Constitution, though, one of the things we look at in unpacking this is whether something is speech or whether something isn't speech. Say, for example, it's conduct. What we do is we ask what is triggering the government's regulation of it. So if the government is regulating what you're doing because you're communicating a message, then that's likely speech. On the other hand, if what's triggering the government's regulation is something you're doing, then that's probably conduct. So in the case of something like Bitcoin, if it's being used to transmit messages, if you're using blockchain technology to transmit messages, private messages, and the government is regulating that, it doesn't want you to have private messages, then that's probably a regulation of speech. On the other hand, if you're using Bitcoin just as the equivalent of electronic US dollars in order to do a real estate transaction, then that's probably conduct.
And I think the key thing that, at least for me, it seems very easy for a lot of people to fall into this trap of thinking about whether something is speech or whether something is conduct, when of course most things are both, right? Like right now I'm engaged in speech, but I'm also engaged in the conduct of moving my mouth and expelling air from my lungs. And, by the same token, if you walk into a bank and say, give me all the money in the drawer, that is speech. And it is also bank robbery. So everything is speech and everything is conduct. And where the courts have fallen on this, which I think is a useful frame for thinking about it, is it's not so much that we care about whether what you're doing is speech or is conduct in some sort of platonic sense. We care about what the government's doing. Is the government trying to suppress the communication of a message? Or is it not? Because what the First Amendment is about preventing the government from making laws that infringe on the freedom of speech. And so we care what triggers the regulation because we care what the government's doing as opposed to caring about what you're doing in some sort of philosophical sense.
Right. And, maybe a simple example is thinking about fire, right? As saying, is code speech is the same as saying, is fire speech or conduct? It depends. So you can imagine in a national park, they have an absolutely strict rule, no burning anything. You can't even smoke. And then there's a Native American rights protest. They have a drum circle and somebody lights an American flag on fire. Now, if that person gets a ticket because there is a uniform, under no circumstances can you light anything on fire because we're petrified of forest fires, then what the government is regulating there is the conduct of burning, not the protest speech. On the other hand, if this is a law the government never enforces, and what they do is they decide, say, hey, those guys are disrespecting America. We're going to issue them a burning ticket, but we're going to do it because we don't like their message. Then the exact same enforcement, even under the same law, can become a regulation of speech. And so Bob is exactly right that we have to look at what the government is doing more than what you're doing to determine whether the courts are going to treat it as speech or the courts are going to treat it as conduct.
So in this case, the code is speech example, it is conveying a message because obviously the purpose of the message and the money would be something like, I just transferred, the message is I just transferred $10 worth of Bitcoin to Jeff Rose. How how does that work with something like the fire example?
Well, I think that the problem, or the kind of conceptual problem with the money is speech, full stop, period, is this idea that code is something that's written down. It's something you could see on a screen, or you could hit a printer and you'd get a bunch of characters that would be printed out. And so there's this intuition that it's speech as a result of that. But if you're transferring the money, the transfer might say, I have just sent so-and-so 1 Bitcoin or 10 Bitcoins, but that's fundamentally no different than me just making a transfer to Bob's account in US dollars to pay him back for something. And so generally speaking, courts are probably not going to treat the movement of virtual dollars or electronic Bitcoin as expressive conduct, unless it had some special expressive component under the specific facts of that case.
Or if maybe it's being, to your point earlier about looking at what the government is doing, if they are treating maybe transfers of Bitcoin more harshly than, I guess, would that matter if they treat transfers of different kinds of money differently just based on the means that you're using?
Well, it's not that the government is treating it more harshly. The trigger isn't, is this harsh or not harsh? The trigger is are you communicating a message? If the answer is yes, then likely whether you're using Bitcoin or you're using some other, you're using 2 cans with a string between them, then the government is likely regulating speech. And so the constitutional framework here isn't something that is peculiar to Bitcoin. It is a constitutional framework for looking at the distinction between speech and conduct in other contexts as well.
And I think that's right, but the constitutional framework does get pushed in interesting ways when you move it onto the internet, when you start talking about code. And this is something, it's something that at IJ we've been litigating since the 1990s. We've been doing internet cases since before it was cool. We sued the CFTC about internet newsletters in the middle 90s. But I think the question of when speech is code actually gets kind of complicated, right? Because code is at bottom a set of instructions, and the government absolutely couldn't make it illegal for me to give Jeff instructions on how to build a chair, right? Though that's speech. I'm telling him how to build a chair. That's classic speech. And it couldn't stop me from giving him instructions on how to 3D print a chair. Could it stop me from giving him the code that would make his 3D printer print a chair? Is that still communicating a message? And if not, why not? Is it that my code has gotten my instructions have gotten too complicated? I'm saying too much, and so suddenly I'm not speaking. I sometimes think of this as, code is kind of like a choose your own adventure book, right? At the bottom of every page, it says, if you want to do this, go to page 17. If you want to do that, go to page 18. And choose your own adventure books are protected by the First Amendment. And code is a choose your own adventure book that's just like 87 million pages long. And not especially discernible to the human eye. And the question becomes, at what point does that tip out of the speech box? And what is it that tips it out of the speech box? And that's something courts have never really grappled with. Kind of at what point does my choose your own adventure book tip over into something that's no longer speech? When does TurboTax become the practice of accounting? When do online services become the practice of law? And I think that the right answer to that is that they are just choose your own adventure books that have gotten very long, but it's an area that the Supreme Court has never really delved into. And it's an area that, I think it's easy to look at it and say code is speech. And there's an argument to say code is speech, but it's not an argument the Supreme Court has accepted. And so I worry sometimes when I hear people being very blasé about the idea that code is speech, we're in the First Amendment box, everything is fine. I'm not saying you're out of the First Amendment box, but I'm saying you're in the midst of that fight. And it makes me a little nervous when people act like the fight is over and has been won.
Right. It's not over at all. And you can be certain that, as these difficult cases come up where it's not obvious whether you're in the speech box or in the conduct box, that the government will be advocating zealously in the courts that this be treated as that whatever the particular instance is, it's treated as conduct. Not just that, the big danger is the government arguing for and the Supreme Court accepting some sweeping rule that says that will be exactly like if the Supreme Court adopts a sweeping rule, the sweeping rule will not be code as speech. The sweeping rule will be code is not speech, code is conduct. And even if you can point to individual instances in which code appears to be speech or has a speech component, that the court will just say, well, that's just permissible over-inclusion in the course of regulating the underlying conduct of whatever. And so this is something we see at IJ and that we've been consistently fighting against in our First Amendment practice is this creep, this analytic creep in which more and more speech is consumed by the conduct box. And that's really the key fight is to make sure not only that we stay in the free speech box in these tough cases, but that courts don't adopt sweeping rules that just by definition put people in the conduct box.
As this is developing, does the idea of public safety have a role to play, like a legitimate public health and safety concern? So with your fire example, the protecting the national forest from getting completely wiped out with fire seems like even if you have to be over-inclusive, there's like a really good government rationale for doing that. If it's maybe 3D printing, a sculpture versus a printing a gun or printing a hatchet or something, does that have any role to play if you look at it from a First Amendment perspective, or does that move it into a completely different kind of analysis?
Well, the fire example is telling because what the government is regulating, at least in the national park context, is the fire itself, the danger that this actual fire presents to the public. And so if you wrote down a plan to somebody that says, this is how you light a fire, you take two sticks and you rub them together, there's no question that transmitting the plan about how to make a fire is protected speech. In fact, I could sit down and draw up schematics for creating a nuclear weapon. And I could pass those around and I could have various engineering friends talk about it. But it's a different story if I actually print the 3D gun and it is a functional firearm and I take it on an airplane and the government says you cannot take a functional firearm in the airplane. It's no defense for me to say, well, I created this using protected speech. What the government is regulating at that point is a functional firearm on an airplane.
What about the instructions themselves for something that potentially could be used? Like, that's just that idea of the potential use of the nuclear weapon or the firearm, like that would be maybe more protected, but it really clearly moves into conduct once it's already done and you've violated some other law.
Well, I think that goes to sort of an idea that is at the heart of a lot of the Supreme Court's First Amendment jurisprudence, which is that we can restrict people's conduct when it's dangerous, but that it doesn't necessarily follow that we can restrict your speech because someone's going to do something dangerous with it. And so you can't prevent beer manufacturers from printing the alcohol by volume of their beer on the label just because you're worried that, people will choose the most alcohol and they'll get super drunk and make terrible decisions. I mean, they very well may, but people are adults and we don't restrict your speech because other people are going to be irresponsible with it in the same way that you can't make it illegal for Jeff to teach me to build a fire just because I might not be responsible in where I build that fire. And that's really sort of the core insight that you're getting at in a lot of these unsettled areas about 3D printing and coding is that we're worried about what third parties are going to do with this information. And fundamentally, the third parties have to be dealt with themselves, usually, when you're in the First Amendment analysis mode, not rather than sort of preemptively saying that speech might lead to dangerous consequences. I don't like the decisions someone else is going to make with that speech. The First Amendment tells us that people are basically adults and we have to treat them as adults rather than withholding information from them because we think they're going to use that information poorly.
Right. And, it's worth noting that there's an extra layer of subtlety in constitutional analysis that people sometimes don't appreciate who aren't lawyers. And that's that whether you're in the speech box, if you're put in the speech box, that's not an automatic win, just as it's not an automatic lose if you're in the conduct box. What it means to be in the speech box is that the burden is on the government And typically, the government has to satisfy strict scrutiny. It has to show that it has a compelling interest and that its regulation is narrowly tailored to advancing that compelling interest. So a case we've been relying on for over a decade is Holder v. Humanitarian Law Project. And the question there was whether or not lawyers could give advice to terrorist groups about resolving their grievances nonviolently. And the Department of State said, look, this is just conduct. We're generally regulating conduct when we're regulating interactions with terrorists. So any speech that happens has to be treated as conduct. And the Supreme Court said, no, this is speech. What's triggering the regulation of this lawyer's speech is just speech. But the Supreme Court ultimately said this is one of those exceptionally rare cases where we are going to uphold the regulation, even though it is a content-based regulation of speech, because there is indeed a compelling interest, and this is narrowly tailored in stopping violent international terrorists. And so it's important to recognize that when we say that code is going to go into the speech box, what that just means is the government has to satisfy strict scrutiny. So, I mean, in theory, if the government can show that the transmission of some information is certain to cause like massive real world harm, then it's possible the government could in fact suppress that, although it's exceptionally unlikely.
So to kind of close that with this context, to kind of close the loop on the idea of code as speech, how, I guess, if we wanted to move the law in a more protective direction of code or of cryptocurrency in that speech area, how do you think it should start, or how is it likely to start, and go well? You know, there's a lot of ways that I imagine it could go badly. You know, bad facts make bad precedent. What is an example of one that could potentially start to move it in the right direction of an example of code being potentially protected as speech in a cryptocurrency context?
So I think the way to start making good law in this area is to look for the thin end of the wedge when you're dealing with internet speech and the sort of cases that IJ has brought that are about, you know, things that are clearly communication, that are real estate advertising or investment newsletters or teletherapy. And I think those are more likely to get a good reception with the courts rather than saying something more sweeping like, look, it may look like this is a financial transaction, but underlying that financial transaction, it's all ones and zeros are numbers, and numbers is speech. And that means you can never regulate this at all. Because I do think Jeff is right that there's the possibility that there's a sweeping constitutional rule in this area, but there's almost no chance the sweeping constitutional rule is good for the people who favor limited government. It's going to be the courts saying this looks terrifying, and that means the First Amendment has absolutely nothing to say here. And so what you want to do is proceed incrementally. And generally speaking, I think anyone who tells you that they can bring about a revolution in the law in the next 2 years is someone who is unlikely to bring about exactly the revolution they think is going to happen.
Right. You know, and in fact, it's the very potential of revolutionary technologies like Bitcoin that are going to drive the court, which is conservative. I don't mean it in the political sense, but I mean in the we don't like change sense, is conservative and will go back on that. Because one thing that, if you look at the larger sweep of Supreme Court jurisprudence, one thing is true, is the Supreme Court doesn't really mind providing maximum protection for speech that everybody agrees doesn't matter. So like you can have some weirdo neo-Nazi marching through a neighborhood. It's annoying, but that speech has no chance of convincing anybody of anything. But on the other hand, if you have commercial speech, right, advertising that actually does influence people, then all of a sudden the Supreme Court is like, whoa, let's slow down here. We need a special test for that. And then, you know, for the longest time you had, occupational speech, and courts were like, whoa, this is just completely incidental to the practice of a profession. If you're actually talking to someone and they're going to take your advice, we can't allow the First Amendment to apply to that. right? And so the very fact that Bitcoin has such potential means the temptation is really large for the Supreme Court to treat this the way it had for years treated occupational license or occupational speech, namely as something by definition that's just outside the First Amendment. So I would like to see I would like to see cases brought on their facts. I want both the people who are litigating the cases not to say there's some overarching principle that solves all problems and I want the court to announce it, but rather to say, under the specific facts of this case, the government is regulating speech. Therefore, the First Amendment applies. Therefore, the government has to carry its affirmative burden. And that's what, have the law develop on a case-by-case basis, the way constitutional law is supposed to develop.
Well, speaking of revolutions in the law, why don't we look at Bitcoin from the perspective, or just cryptocurrency in general, from the perspective of the Fourth Amendment? As a lot of our listeners will know, the Fourth Amendment protects against unreasonable government searches and seizures, tied to our concepts of privacy and of being secure in your property. And as people familiar with Bitcoin know, it's powered by blockchain technology, which I will not claim to fully understand, but do know is essentially a decentralized and public digital ledger. So if we think of crypto as being private and even anonymous, but really that's only true if transactions aren't tied to specific people. So that immediately seems to pose a privacy concern, if not a direct property concern right off the bat. Does the Fourth Amendment protect against the government tying your name to a Bitcoin wallet and then suddenly getting access to your entire transaction history?
So that's a really interesting question, and it's a cutting edge area of Fourth Amendment law right now, because it really requires you to understand that the intersection of both privacy and how kind of financial privacy works in this country. And, the way financial privacy works in this country is that it basically doesn't. And so there are two things happening here. One is, as you say, the blockchain is, we think of it as private, but it's very public technology. All of your transactions are public. It's just they're anonymized. No one knows who owns which wallet that's engaged in this transaction. But once you can tie a wallet to Jeff Rose, you can go back and see every transaction Jeff has ever engaged in over the entire course of his life. And that intersects interestingly with the way we regulate banks in this country. And that, to understand that, the story there, as with all good stories in constitutional law, begins with a fire in an illegal whiskey distillery in 1973. Local police found an unlicensed whiskey distillery, and they figured out that a guy named Mitch Miller was leasing the warehouse where they found this distillery. And so they went to the bank and they subpoenaed all of Mitch Miller's financial records. And they said, we just want to see what this guy has been up to. And we're going to track it down and figure out that he's a bad guy. And Miller said, whoa. You don't have a warrant. You can't just get my entire life from the bank. And that case went up to the Supreme Court. The Supreme Court announced what's called the third party doctrine. And they said, look, nobody searched your house. Nobody came and went through your stuff. When you gave this information to a third party, to a bank, that means the government doesn't need a warrant to get it from the bank. You have no expectation that you're going to remain private once you give the information to a third party. And the government has taken the third-party doctrine in the context of banks and just run with it as far as it possibly can, to the point where banks are, under what's called the Bank Secrecy Act, required to file all kinds of reports with the federal government about your transactions. They're called suspicious activity reports, and the government concedes they get more of these than they can read. They get one a minute. Nobody reads them. And all they're doing is just creating this giant database of financial transactions. They can kind of troll through and do keyword searches and just sort of figure out if anyone's up to something shifty with the giant database. And that's the classic thing that you would not be allowed to do in a world where you had Fourth Amendment protections, right? I can't just, I'm going to search everybody's bedroom, not looking for anything in particular. I just want to create a giant database of what's in everyone's bedroom so I can do keyword searches and troll through it and see if anybody's up to something they shouldn't be. But you can do it with banking information. And the question becomes, as Bitcoin and other sort of e-coin technologies like Ethereum become actual financial instruments that banks are transacting in, can the government demand that banks turn over information about who owns what wallet, not just their own customers, but the other side of a transaction they're transacting with? And it's something the government's proposing right now. Our IJ clients, Rob Johnson and Rob Fromer, because everyone who does good work at IJ is named Rob, have written a letter to the federal government making exactly this argument, that it's, even if you accept the third-party doctrine, and we should talk about why you shouldn't, but even if you accept that, there's a huge difference between having a bank turn over its own records and turning over the identity of a third-party owner of a Bitcoin wallet, because that's turning over that person's entire life in a way that really does raise Fourth Amendment questions that have not been litigated and that are going to be litigated if the federal government goes down this road.
Right. And, the Supreme Court is having to grapple with all of these privacy issues in the smartphone context, first, and then shift into the Bitcoin context, because a smartphone isn't like an old phone. If you get a hold of somebody's smartphone, all of a sudden you have access to their whole lives. If you can get past the first password protection, all of a sudden maybe you can get into their banking apps, you can get into their texting apps, you can get into their email, everything. And so the Supreme Court is having to reframe a lot of their doctrine in the past, which was sort of based on the obvious physical presence of things, right? Like, so the police walk into, you invite the police into your home to give CPR to your grandfather, but then all of a sudden they notice that there's like some marijuana sitting in the corner or something like that. And, are the police allowed to act on that? And so the thing about the Bitcoin poses, like smartphones, is that you have all of this information. It is virtual. It is high, and this is the other thing, is it is highly searchable. That's the thing that the capacity for government surveillance now is massive, because they can use computers to do it. It's not just somebody going around inspecting physical spaces. And so the Supreme Court's general framework in the past, which is like, if you've put something out in the public, like if you're standing in the public holding up a sign saying something, you don't have an expectation of privacy in what you're doing, and therefore the government doesn't need a warrant or whatever to come over and talk to you, or that kind of situation. But here, people have very strong expectations of privacy, and especially if people start using peer-to-peer Bitcoin technology to circumvent banks, right? This is the government's big fear, is you have something like Silk Road, where people are making transactions that are otherwise very difficult to track. We should acknowledge that the looming specter of the war on drugs is what's driving so much of this, because it's just this paranoia that the government has, this never-ending paranoia that someone out there might be engaging in a drug transaction, or maybe in some other illegal transaction, but mostly in a drug transaction, and the government doesn't know about it. And the government wants to know about that. Therefore, nobody has any privacy in anything.
Well, I mean, and it sounds horrible from that 30,000-foot view, when you consider that probably every one of us on the podcast and every person listening is probably, we're sort of caught up in this. Could you talk about it from a little bit more of a personal perspective? One of the areas where IJ's work in the past has kind of intersected with this banking regulation and the consequences that it has for ordinary people and completely innocent people is in the context of structuring. So can you use that to give an example of why this isn't just a conceptual Big Brother fear? This is something that can really hit people in a very practical level, just trying to go about their day-to-day lives, not engaging in anything that would potentially be, freak people out kind of transaction, just a normal doing business transaction.
Well, sure. So we've done a number of cases that involved IRS seizures or government seizures of bank accounts of ordinary businesses on the grounds that either they were depositing more than $10,000 or they were structuring their bank deposits to avoid hitting the $10,000 threshold. And so, this is IRS paranoia at its maximum. Like, we're watching not only for suspicious transactions over a certain amount, but also suspicious non-transactions or transactions under a certain amount, in which case every transaction at that point, every transaction is by definition suspicious. We had some clients, for example, who their insurance company said, you can't have more than $10,000 in your safe. We won't insure $10,000 in cash. So whenever your business gets close to $10,000 in cash, go put it in the bank. But of course, what that does is set up a regular pattern of sub $10,000 deposits, which the IRS regards as suspicious because they think you're structuring to avoid the reporting requirement for a $10,000 transaction. And so we can, I can certainly envision certainly the government will advocate for all sorts of rules, including various exceptions to the warrant requirement to keep an eye on these transactions, and the government will say these transactions are public. Anybody can review these ledgers. The problem is we don't have a name associated with the string of numbers for each transaction, and say, well, we just need to have a key somewhere. We need to have a list somewhere that matches this up to people's names. And that strikes me as extremely pernicious and dangerous, and something that will have to be zealously and emphatically resisted.
And those IJ cases, I think, illustrate the problem with removing Fourth Amendment protection from this area, because when the government doesn't have to comply with the Fourth Amendment, it establishes a giant database of every bit of information it can get its hands on. And it's very easy to think, oh, well, if I'm not doing anything wrong, I have nothing to worry about. But the IJ cases illustrate exactly what's wrong with this system. One of the things that triggers the bank's requirement to file one of these suspicious activity reports, the ones the government admits it doesn't read, is depositing an amount of cash under $10,000. That's suspicious. And so that triggers a report. And it's not like there's a human being who reads all these reports and says, oh, this is Carol Hinders. She owns a small cash-only Mexican restaurant, and so that's why she's making these deposits. It's just, let's run a search of everyone who's depositing under $10,000. Let's seize their entire bank account, and then let's make them explain to us why they're not criminals. Which is exactly the system for years until IJ got on their case. For years, the IRS did this to anyone it could find. And I think that's exactly why we don't do law enforcement that way. We don't do searches that way, that things are supposed to be specific to the person. You're supposed to conduct an investigation. You're supposed to develop probable cause about the person instead of just, you fit this general pattern. And once you fit this general pattern, I can seize your bank accounts, I can freeze your life, and I can demand you justify yourself to me. That turns the Fourth Amendment, that turns the entire system of American criminal justice on its head.
And indeed, it's so pathological that we have clients and other people out there who routinely have evidence that says, this $80,000 you seized, this is from my business. And then the IRS says something like, okay, how about we settle? We'll keep half and you get half back. Like, that's the response. And then they have to start working through that. Like, you have to settle with the government to get back money that it had absolutely no justification in seizing and did so in violation of the Constitution. It's ludicrous.
So same question in the Fourth Amendment context that I asked in the First Amendment context, which is, how do we make things better? What is, knowing that this is going to be another incremental fight, especially if it's something that goes back to, the whiskey, the third-party doctrine and the whiskey fire. How do we start to move it in the right direction? Is cryptocurrency potentially that case that can start to say, okay, look, this is exactly how bad this can be, because you could see everything about someone, not just that transaction that you decided should be flagged, but everything about them.
I do think it's an area where there's a possibility for useful litigation. And I think really the thing to do in the Fourth Amendment area, and the way to push back against the third-party doctrine and the sort of panopticon that it enables, is to try to refocus the court on the Fourth Amendment as a protection for property rights. That what really matters in this context is property rights. And it's a line IJ has been pushing that several members of the Supreme Court seem to be inclined to pick up on. But we don't need all of these strange questions about angels dancing on the head of a pin if we just ask whether someone has a right to the thing that you're searching or seizing. It doesn't matter whether I've given it to a third party. I can give my property to Jeff, and I can say, Jeff, hold on to this suitcase for me, but don't open it. And Jeff says, I promise not to open your suitcase. And the logic of the third-party doctrine would tell us, oh, well, that should mean that the government can open the suitcase because Jeff's holding it, and Jeff's a third party. When if Jeff himself opened it, I could sue him. I could say, Jeff, you broke your promise. You violated our contract. And I think those ideas are much more important. And if we recenter them in our Fourth Amendment jurisprudence, a lot of these questions that right now seem cutting edge and difficult and mind-bending start to get a lot easier, and they start to get a lot more privacy protective.
Right. And, I think that having a personal property right oriented view allows the court to create principled jurisprudence instead of what goes on now, which is this ongoing negotiation between the Supreme Court and the government about what an individual's reasonable expectation of privacy is. And what that has done is created a jurisprudence that it really isn't a set of protections under the First Amendment, but is a roadmap for the government to, here's how you violate the Fourth Amendment, here's how you violate privacy. The other historical truth is that the Fourth Amendment has deteriorated in direct proportion to the degree that surveillance technology becomes more and more sophisticated, right? So it seems like virtually every time the government is able to ramp up technologically its ability to engage in surveillance, the government comes up with a justification, especially a third-party doctrine type of thing that says, look, so-and-so is using this technology to put their information out there, so they don't have a reasonable expectation of what's out there. And it is the nature of technology and communication technology and financial technology that we are going to be putting stuff out there. And so what we have to do is really focus in the right cases on getting the court to recognize that there is a principled individual right to retain control of your information, just in the same way you retain control of your own physical property, rather than ask the government, do you think that these people have a reasonable expectation of privacy in this thing that is admittedly is a public ledger? That it seems almost certain that pursuing that road will just create more and more roadmaps for the government about how to violate privacy.
To wrap the conversation up, how do you both think about this as you look even further ahead? Obviously, the currencies that we're talking about now were not imaginable 50 years ago. What about the innovation 50 years from now? How do we ensure that the law that's being developed can protect that?
Well, I think that the most important thing is for us not to think about broad, sweeping rules that are going to have definitive solutions to problems we can't even imagine, but rather to have a set of guiding principles that we apply in specific cases in order to protect the individual liberty memorialized in the Constitution. And so I realize that sounds, maybe a little bit philosophical or even a little bit flighty, but these unknown the Constitution can cope with the evolution of new technologies as long as we continue to remember that our individual rights are paramount, the government's prerogatives are subordinate to those individual rights, and that we have to work out each individual's situation with that framework in mind.
I think that's right. And I think the most important thing, obviously, is having a set of consistent principles that you can apply. But I also think this whole debate illustrates the importance of choosing the cases in which you deploy those principles. I mean, in a way, it's nuts, right? That our discussion of your privacy rights in Bitcoin center on what happened in a whiskey distillery fire in the 70s. But that's how the law works. And so part of applying those principles is, when we apply them, trying to see around corners a little bit, trying to figure out what the next fight is and what the consequences are of the rules we're establishing. And it's something that comes up a lot, frankly, in IJ litigation. 15 years ago, I was litigating cases about whether tour guides could be required to get a license. And people would say, why tour guides? Why do you care so much about people talking about Ben Franklin? And, it's not that tour guides aren't important in and of themselves, but part of it is we're trying to see around corners. We're trying to establish these principles in a way that will help protect us as speech on the internet becomes more important, as it becomes more important to stop the government from bringing its licensing and regulatory authority into communicative spaces that we haven't seen yet, but that we're starting to invent. And I think it requires a large dose of humility. You have to know you're never going to predict what the world is going to look like in 50 years. But you have to do your best to make sure you're cementing your principles in a way that leaves that world best positioned to defend itself. You don't know what it's going to be and you can't defend it. All you can really do is try to set a groundwork where the future can best handle itself. And that's a lot of what I think public interest lawyers are trying to do, and it's a lot of what thinking in this space is centered on.
Well, thank you both for joining me. Thank you to everyone for listening. If you enjoyed this discussion and would like to hear more like it, you can find more episodes of Deep Dive wherever you get your podcasts or on YouTube. And don't forget to subscribe.